Well, good morning, folks. Happy Wednesday. It is June 7th. Can you believe it? We've made it out of the long winter. And well, given the weather this week, it seems like winter was not ready to give it up to warmer weather. Midweek, but we're also sort of mid-year. And so where we are is looking at a year in review. This is the New Hampshire Tech Alliance. My name is Jim Reedy, and coming to you from Sheehan Finney this morning. This is the Tech Alliance's HR Exchange. This is our June meeting. Typically, we have one meeting at the end of the year. Our program year, which is June, will start up again in September. But this is our annual labor and employment law update, which is sort of a year in review so far, and it's a preview of what could be coming next. So welcome. We've got well over a couple hundred people now registered this morning. And one thing I want to mention from the outset, and Liz Tesic is good to continue to remind me of this, is that this program is eligible for SHRM credits. They're available at the end of the program. You'll see that slide. In addition, Liz will email out to you the presentation along with the slide information and the SHRM code. And this is also being recorded and accessible later. So there we go. Employment law year in review. It's been a busy year because it's 2023, or as we like to refer to it, 2020 plus 3 minus the sum of COVID, if for those math majors out there. But it's been certainly, and so speaking to the choir here, it's been a busy year, but it's a busy year because we're in that post-pandemic world. Thankfully, the public health emergency has ended as of the month of May. And with that, there's some guidance that's come out, as you know, the recent guidance that just came out with regard to healthcare employers and the COVID vaccine and vaccine mandates. In fact, our firm just did a client alert on that, and that's available. We've been sending it out since last night. But if you'd like a copy of that, just email me separately and we'll get that along to you. Can you still have a vaccine mandate? Well, certainly you can. EEOC guidance is still good in that regard, but it's going to be based upon it has to be job related and consistent with business necessity. That being said, as you know, there's been a lot of pushback. The numbers, which we'll talk about in a minute, the numbers for people getting the vaccine has dropped off significantly. I think it's around 16% of the population now is up to date on their vaccine. So we'll talk about that too in the context of long COVID, something that most employers are going to have to deal with, sadly, for at least the near future. So as we settle into this post-pandemic world, the question is, how are you doing and what could be next? So, and I say that again because while COVID may be in the rearview mirror, thankfully, actually I heard as of last night that it's popping up again. And what we're talking about there is typically the variants, and because it's a virus and viruses mutate, but we still have to be on guard. But if we're putting COVID aside for a moment, we're also still dealing with low unemployment, wage inflation, brisk competition for vacant positions, and mounting pressures, principally from within your organizations, dealing with sort of the adjustments in the economy to whether or not some of these COVID related accommodations have to continue. And I'm looking here to the side for a second, if you don't mind. I realized I didn't mute my phone, and I don't want that going off during our presentation. So there we go. All right. But I do want to talk about those COVID related accommodations because I think we did a program in November of this year dealing with layoffs and RIFs, reductions in force. Typically the high period for that is November to January. We're experiencing now something it's certainly out of cycle where more and more employers are looking to right size their workplaces. That could be because of the economic pressures, everything from energy costs to supply chain issues that remain. But it could also be, like I said, because of high wage inflation, or it could be because the pandemic taught us that perhaps we don't need as many people in certain function. It could also be the rise of AI and automation. There's no question that there are tensions in this market, and the tensions relate to return to work requirements. I don't know if you heard the other day, Amazon required their employees to come back to work. And many of them said, we're not coming back. And if you require us to come back, we're walking off the job. And of course, I had to snicker a little bit thinking, but if you're remote, how do you walk off the job if you're remote? But it is a serious issue, and it's one that relates to that whole notion of quiet quitting, which became a phenomenon last year, but it remains as a part of the next generation of the Great Resignation, which was related to COVID in 21 and 22. Should remote work accommodations be indefinite? Well, that's a question, and that's a burning question these days. And for those going to the SHRM conference in Las Vegas this next weekend, I will be there, and this is one of my topics that I'm speaking on. I'm doing remote work, and I'm also doing one on long COVID. But generally speaking, work accommodations, they don't have to be indefinite, and because that could create an undue hardship. But that could be changing too. There is case law, but the case law is sort of a pre-COVID case law. Wage inflation, you know that while there's a push to increase the minimum wage in New Hampshire, which we're still at $7.25, which is the federal, we're also way out of step with a lot of other states that are in the teens at this point, $12, $13, $15 an hour minimum wage. And that's the minimum wage, statutory minimum wage. But as we know, a lot of your competitors, or you just simply drive around, and the example that people most likely use is the starting wage at McDonald's, and it's $17 an hour, sometimes higher. Low unemployment, it still remains low because New Hampshire, and in some ways that's a good thing, we have a vibrant economy, and where unemployment is as low as 2.2%. If full employment is 4%, you see where we are on the scale. And nationally, it's 3.6%, so still below full employment. But that's, again, underscores the fact that you have vacant positions, or that you're hiring people that you might otherwise not hire, but it's a tight market. That's because also labor participation numbers remain low, in the low 60s. 60% of those eligible to work are indeed working, at least as it shows up in the Bureau of Labor Statistics surveys. I think we can all agree that some people are working under the table, or that some of the work is not reported. But still, it shows perhaps a lagging indicator from COVID, but perhaps it could be something more symptomatic of bigger issues. So, in other words, it's a difficult market for recruitment and retention, and it remains that way. Yeah, I know this sounds very familiar to you. In April of this year, there are 11.4 million jobs available. Also, at the same time, 4.4 million quits, people leaving their jobs. So there's great mobility in the marketplace, and I went through the national statistics and the state statistics for unemployment benefits, but vacancies outnumbered unemployment by 5.5 million. So that's tells you that we're still in a very challenging hiring market. But that then there are potential traps in that regard. A lot of employers have been out there doing sign-on bonuses, retention bonuses, and offering a higher starting wage. But while there are some benefits to that, and certain real benefits to that, but there are also potential traps as well. So where have all the employees gone? Some back to school, although the tuition repayment issue is one that is surfacing, where after a hiatus or a pause of a couple of years, student loan repayments are going to start again. Are people taking a break to re-examine their priorities? That was more of a function of COVID because of this deadly virus. We could talk about that in the quiet quitting context too, but maybe. or they're working for another company who paid a signing bonus, and there's great mobility in the marketplace because people are chasing the dollar. Or there's a startup they're doing a startup in their parents' basement, or alien abduction. Who knows? But the bottom line is that there's a lot of mobility in the marketplace, and there are still vacancies. If only 6% of employees worked remotely before COVID, how many were working remotely now? What do you think? It went as high as 60% of employees during COVID. But that number has come down a bit to around 40%. And again, it depends if you count Amazon employees. So are we witnessing a cultural shift, meaning from the workplace to cyberspace? And this slide says that we're down to 33% are now working remotely. I think that it depends on the numbers, because if you look at hybrid work, it's as high as 40%. Major employers permit indefinite work remotely: Apple, Facebook, Google, and Microsoft, but that too is changing because executives disagree on remote work impact on cultural productivity. Meaning there was a study that came out, believe it or not, from Newsweek. I didn't even realize Newsweek was still around. And it said that that remote workers and in-office workers were just as productive. It also said that they each wasted just about the same amount of time. The problem is the C-suite looks at it. There was a survey that came out and said that a majority of CEOs and CFOs believe that remote workers lack hustle. And also, if you're looking at the commercial real estate, it's hovering around 40% occupancy. And so it's expensive real estate. And I was talking to a fellow from a financial industries employer from St. Louis, and he was saying that things have changed. Whereas they were fully remote, now they're told to come back in the workplace at least 3 days a week. If not, they're written up and they're subject to discipline. And this is a white collar workplace. So I think things are changing. And there was another survey that came out. If there's going to be a reduction in force, a majority of executives said that remote workers could be on the chopping block. Now, that's a bit vexing as far as I'm concerned, because didn't we allow remote work because we valued these employees and we needed them? So apparently there's some sort of a shift going on in that regard, saying, look, you've got to come back to work and you can't resist. But that resistance is what caused the rise of quiet quitting. More states are adopting, well, let me go back to quiet quitting for a second. You've heard the concept of a bare minimum Monday, and that came up from a TikTok video, but that's employees easing into the work week, not starting at 8, not starting at 9, but easing in a bit later. And then, of course, there's a whole notion of what we refer to as full stop Friday, where somewhere around 11 or 12 on Fridays, employees no longer responding to emails or just basically ratcheting back their work. But the quiet quitting was for the employees that decided not to leave their workplaces, but also said, I'm not going to kill myself in this job. That could be COVID related. That could be a re-examine of priorities. It could also be a generational issue, because there's a great generational difference between baby boomers making those decisions, because a lot of baby boomers unretired because of changes in the economy. But there's also differences between Gen Z and Gen X in that regard. But quiet quitting, some of that is being sniffed out in the workplace based upon productivity and so on. Lots of other issues that have come up, but I want to go back to quiet quitting for a quick second here. During 2021 and 2022, as many as 4 million Americans left their jobs every month. And there was a study that came out that said as much as 60% of them actually regretted the change because the grass wasn't greener on the other side. But we are certainly experiencing, I think, a change in our culture and our workplace related to work-life balance, and that's not necessarily a bad thing. More and more states are adopting paid leave laws, and that's a reflection of the need for employers to recognize that to retain employees, especially employees with family issues, and especially when you've got two in the workplace working to support a family, that there's a need for paid family leave laws. In other words, the FMLA from 1993-95 didn't go far enough with job restoration because it was unpaid or largely unpaid. So now moving towards paid family leave laws, and we know that New Hampshire, Massachusetts, and Vermont all have paid family leave laws. And there are also parental leave laws that have come up. And then you have the advent of unlimited PTO. And perhaps this is the exhaustion of HR professionals in tracking PTO, along with all the many other things that they have to track. But that's an interesting concept. And I know many of the employers, even in the state and with operations beyond the state, have adopted something similar. And there are certainly benefits to it. But let's compare that to states that are now encouraging, or employers on their own are adopting a 4-day work week. In Massachusetts, there's going to be a trial program for a 4-day work week, and it's a tax benefit to employers that do that. I had an HR professional come up to me at a talk I was doing in Washington in March, and she said, we're going to a 4-day work week. And I said, that's great. Are you talking about 4 10s? And she said, no, 4 7s. So you've got certain benefit thresholds and also productivity issues. You also have, and at the same time, she said they're also doing unlimited PTO, which again is a decent concept. The problem is, how does that work when you go to a 4-day work week, but you have unlimited PTO, which may then erode the number of days that the person may be working. And again, you may get the pushback from the C-suite because of the limit or the impact upon productivity. And has there been a rising tide of workplace claims? The answer is yes. You know, typically when you see low unemployment, you see the discrimination statistics either leveling off or declining. That's because employees have options. If they're being harassed or discriminated against or retaliated against, they simply dust off their sandals and go somewhere else. It's not true in every instance, but that has been a statistic. The problem is that during COVID, there weren't a lot of other places to go to. And so we saw, and we're seeing now a steady increase in discrimination statistics from EEOC. And their tracking is October 1 to November 30th. So it's a different fiscal year, but we're seeing the numbers increase, and we're seeing the same old favorites, top 3 being retaliation, discrimination on the basis of race, and discrimination on the basis of gender, and all the subsets associated with that. COVID policy impacts, there were many. I think that the biggest one there is the pushback with regard to vaccine mandates and exemptions, and failure for an employer to grant an exemption on religious or medical grounds, or accommodation denials. I need to work from home. I need to work from home on a hybrid basis, and so on. And then we're also whistleblower claims. We're seeing more of those related to workplace safety, but also related to other claims that were perhaps glossed over during the public health emergency of COVID. But again, with that subsiding, whistleblowers coming forward. Has the country gone to pot? More states have now legalized marijuana. We are over 40 states that have legalized marijuana in one form or another. And cannabis use skyrocketed, along with substance abuse disorder, skyrocketed during COVID, and that perhaps was related to isolation and the how that impacted employee mental health, which was also a significant increase and largely ignored because it wasn't subject to the triage issues associated with COVID. But cannabis use skyrocketed during COVID. And that could be because of the increase in the legalization, but also because people were home and not subject to either whether it's drug testing or, again, having to come into the office. Retail sales of pot now exceed chocolate in the US. Can you believe that? Now, I'm just waiting for Hershey's to come out with their own THC pot infused chocolate, but just to catch up. But that's a significant change because Americans like our chocolate. will the federal government's position on legalization of marijuana change? Well, there's certainly been a move in Congress for that. But again, many states have legalized, one more again very recently. The Biden administration has talked about it, and they basically were going back to what's called the Cole Amendment, which was a policy under the Obama administration saying that with regard to marijuana laws, as long as the states enforce their laws, and if you go back to the early days of the Obama administration, when just 4 states had legalized recreational marijuana, and you had an issue of one that being at odds with marijuana being a Schedule I narcotic under federal drug laws, and there are issues related to the banking issues and generally with commerce. You also had people going from neighboring states where it was illegal and going into those states and getting marijuana. But the Cole Amendment basically said that if you do certain things to enforce your drug laws, the federal government will not get involved. That changed a bit during the Trump administration. Looks like while it's not a priority, the Biden administration is looking to do the same. But I think, again, Congress is looking at legalizing marijuana and the benefits of that. And a lot of employers in the meantime are waving the white flag, basically saying, we are not testing for cannabis anymore unless we're in a safety sensitive position. If you look at the states around New Hampshire, recreational marijuana in Vermont allowed. The same is true with regard to Massachusetts and in Maine. In fact, Maine, you can't ask about marijuana use at the outset of employment, and you cannot test for it at the outset of employment except for safety sensitive positions. New Hampshire has medical marijuana, but not recreational marijuana, at least not yet. And of course, we know in the North Country, all of Canada has recreational marijuana. So perhaps the smoke you've been seeing in recent days is not only the Canadian wildfires, but perhaps even their marijuana use as well. But there is more change on the horizon. But I think what employers are looking at, again, in this tight economy, is whether or not we're going to bother testing for marijuana, given that it's largely everywhere. And the question is, as long as the person's not in a safety sensitive position. The issue continues to be, however, there is no legal standard for impairment like there is for alcohol. And while there are many people working on this, there is no standard yet. Marijuana use and abuse is now rivaling alcohol with regard to traffic deaths. And so that is something that the state and largely state and municipal police forces have been advocating for some standard for determining impairment. And I think employers would welcome that to determine whether or not, if they test and they find that it's in the employee system, whether or not that it's over the number of nanograms of THC in the person's blood system, or otherwise. But stay tuned on that. So let's look at some of the legislative and regulatory and legal issues from the last year. And then what I'm talking about is basically from the last half of 22 into the first half of 23. In October of 22, the DOL went back to the future with their independent contractor and joint employment rules. Basically, what they're doing is, again, they're going back to the Obama administration standards with regard to independent contractors, which was largely the same under the Bush administration and the Clinton administration, which was basically that similar to our state law tests and the IRS test, there's a presumption that a person is an employee unless you rebut that presumption by satisfying the tests. In New Hampshire, it's the ABC test. It's also which is under the unemployment statute, but we also have it in our workers' comp and wage and hour. But the federal government under the Trump administration had relaxed standards, and perhaps that was related to COVID, perhaps that was related to more of a business-friendly environment. But the bottom line is the DOL is back to a more strict standard, and that is something you want to look at. They also looking at a more strict standard with regard to joint employment, and joint employment basically being two entities acting in concert and one being responsible for the potential bad acts of the others, being a violation of federal wage and hour law or workplace safety laws. There is a new FLSA poster that issued in April of 23 that is available on the U.S. Department of Labor website. It's you can print it out, download it and print it out. It's free. There was a Supreme Court case dealing with a highly compensated employee making, I believe, over $200,000 a year, but didn't otherwise meet the exemption requirements. So the person was actually eligible for overtime, even though the individual was making over $200,000 a year. And U.S. Department of Labor issued guidance with regard to telework. And what are they looking at there? What they're looking at there principally is timekeeping. And I'm sure many of you had the issue with regard to tracking the hours for your non-exempt employees who worked remotely. So apart from productivity, we're looking at timekeeping, and timekeeping gets to not only the standard wage, but also an overtime wage that the employee may be eligible for. And again, it is the employer's obligation to track hours, and but it's the employee who keeps the time record on a daily basis. So that's something that should be monitored, and U.S. Department of Labor has issued guidance on that as employers still permit employees to work remotely, either full or on a hybrid basis. And New Hampshire has relaxed in some ways its hours with regard to 17-year-olds and the hours that they can work. That's been out in the last year. New Hampshire's minimum wage still stuck at $7.25, even though the legislature is looking at increasing that. There are 3 bills, I believe, that are still in the legislature to increase our minimum wage on a graduated basis. But I think it's a tight split between Republicans and Democrats. It is not while there is a Republican majority in the House and in the Senate and in the corner office, there is it's still a Republican majority, and I think there is resistance to increasing the minimum wage. Again, it's the same as the feds, but doesn't matter because most employers are paying well above $7.25 an hour. Tip pooling is an issue, and that relates to the minimum wage as well, because employers can pay, those that have tipped employees can pay below the minimum wage as long as their tips, the employees' tips exceed when taken together with their reduced minimum wage, exceed the minimum wage, and they often do. Unused vacation time, there's a bill in the legislature saying that employers cannot basically divest an employee of earned vacation time. And there's also a bill with regard to payroll cards and direct deposit where you can make those mandatory. As you know, under New Hampshire law, you can have payroll cards, you can have direct deposit, you can have electronic fund transfers, but you also have to have live checks for employees that don't want to go that route. This bill basically says that employers can mandate payroll cards and direct deposit. Still waiting on the developments on those. There have been hearings at the House and the Senate on all of those, and stay tuned. The National Labor Relations Board, again, when you have a change in the White House from one party to another, typically you have a change in the composition of the National Labor Relations Board. And during a Democratic administration, the NLRB typically will become a bit more employee or labor friendly. And we've seen those shifts again from Clinton to Bush, Bush to Obama, Obama to Trump, and now back to Biden. And so there's a flip-flop that goes on pretty regularly. That's not uncommon. What's a bit unusual is the National Labor Relations Board came out and opined for the first time on separation and settlement agreements, adding additional language under Section 7 of the National Labor Relations Act, basically saying that these claims cannot be waived and that the settlement or the separation is not in violation of the statute. And so we've got language we put into our agreements in that regard. But also the National Labor Relations Board opined for the first time on non-compete agreements and restrictions like non-compete, non-solicit, and non-disclosure agreements, but principally looking at non-compete agreements. Now, I know, coast to coast, there are state laws, whether we talk about the general prohibition in California to garden leave in Massachusetts to New Hampshire, saying that if you want to have a restrictive covenant, you must provide it to the employee at the time that he or she receives an offer of employment. Otherwise, it's not enforceable. Also, you cannot use restrictive covenants like that for low-level employees in New Hampshire. And that's pretty much what we see across the country. But this suggests this National Labor Relations Board opinion that just came out from General Counsel suggests that non-competition agreements may be a violation of national labor relations law. So there will be more on that. But in the meantime, our friends at the FTC basically weighed in on this as well. And there was a proposal suggesting that non-compete agreements should be prohibited. Again, we're seeing more on this. That some states have talked about certainly doing away with them, like the California model, but I think we'll stay tuned on that. EEOC issuing guidance with regard to AI. People have heard a lot on AI in recent months, and perhaps even rewatching the Terminator movies. But on May 18th, EEOC issued technical guidance on this, basically saying that the software employers are using in the recruitment and selection process and screening process, you have to be careful in that regard to make sure that, and it's a matter of beta testing to see how this is working, but whether or not and if you're going to have that with the software company, you want to build in certain protections for your organization and indemnity as well, in the event that the system you're using does actually violate federal discrimination laws. But EEOC's guidance, I think, is useful. It's not terribly detailed, but it is useful with regard to guidance for employers on their selection process, especially when they're using software, artificial intelligence to assist them with the recruitment and screening and hiring process. And more will likely come on this topic for sure. I was just listening to a TED Talk this morning on AI, and you've got a whole host of issues. I think Senator Schumer had there are hearings on Capitol Hill today on AI, and some suggestions that could be great danger with regard to, in general, the rise of the machines, but also the impact upon the workplace and what it could mean for certain jobs and certain functions. Let's shift to paid family leave for a second. As many of you heard, my partner Andrea Chatfield talking about this, and she and others in our employment group have written articles on the paid family leave. As you know, a couple of years ago, I think it was proposed very differently, and there was a battle between Governor Sununu and I think it was Senator Feltus with regard to paid family leave. What was adopted finally is more like what Sununu wanted, which was a voluntary program. It covered public sector employers, but also covered private sector employers, but it was an opt-in by not mandatory like in other states like Massachusetts, and it was an opt-in by employers or individual employees. And the MetLife was designated as the insurance provider. It was signed into law in June of 21, but it didn't become effective until January of 23. However, as early as December of 22, employers could purchase coverage. And again, there are different plans, 6 to 12 weeks. Employees covered under the plan, or they could be covered on individual basis through payroll deductions through MetLife and notifying the employer. Andrea shared that as recently as April of 23, only 644 individuals had enrolled under the paid family leave program in New Hampshire. And informal surveys conducted by us at various events in the last 6 months suggest that many employers have not yet adopted their own plan, meaning the plan under this statute. Some are doing it having paid leave separately or comparable plans. But I think this is going to be a process, and perhaps it's going to evolve into the point where it becomes mandatory. But in the meantime, it is still voluntary and there is low enrollment. Another new development that came that will be effective soon is the Pregnant Workers Fairness Act and the Pump Act. And EEOC has issued guidance, will issue guidance rather by December. In the meantime, the Pregnant Workers Fairness Act will be effective in June 27th. And it basically means providing reasonable accommodation to pregnant workers and no forced leave. You can't force someone out before they're ready to take the time. In addition, there's the Pump Act, which was effective on April 27th. Basically, as you remember back to 2009 with the amendments to with the adoption of the ACA, the Affordable Care Act, and the amendments to the FLSA, nursing breaks and protections for non-exempt workers, where it was counted as hours worked. There was a safe place, a clean place for nursing mothers to, with a locked door and a refrigerator for the express breast milk and so on. And some sort of guidance, there was guidance with regard to taking time for that purpose. The Pump Act actually extended this to salaried and salaried exempt employees. So I don't know of many workplaces that said if you're salaried or salaried exempt, you can't have the same protections, but this is the purpose of the Pump Act. Again, remember, salaried and salaried exempt employees, they get paid the same salary. Well, certainly salaried exempt get paid the same salary without regard to quality or quantity of work. They're exempt from overtime. Salaried employees who may be non-exempt are still paid the same salary without regard to quality or quantity of work, with certain noted exceptions, but they get paid overtime when they cross the 40-hour threshold. Again, the purpose of the Pump Act was to focus on extending the coverage under the FLSA to salaried and salary exempt employees, and that is in effect now. And just when you thought it was safe to go back to the workplace, of course, we're coming into summer session and everybody watches Jaws again and again and watches for those dorsal fins. We're talking about the lasting impact of COVID. And what are we talking about here? Well, as of May of 23, May 9th of 23, a total of 104 million Americans tested positive for COVID. And as many as 60% of those who tested positive had additional COVID infections. In fact, many of those who report, well, I'll go back for a second, but many of those who had COVID report lasting physical and mental complications attributed to COVID. That is what is referred to as long COVID. And the Census Bureau in June to July of 22 said that as many as 16.3 million Americans, or 8% of the total working age Americans, reported that symptoms of long COVID. More recent suggestions in 23 suggest that between 10 and 35 million working adults have had long COVID. And what the impact upon the workplace could be, as many as 4 million employees are projected to be out of work due to long COVID. So what does that mean? Again, we talked about the labor shortages. We talked about the vacant positions. We've talked about now paid leave programs and perhaps even remote work or hybrid work. And now you may have employees, whether they're working remotely or in the workplace, to be out because of long COVID issues. And the annual cost in lost wages alone, if they're not covered by sick leave or PTO or family leave, could be between 170 and as high as $230 billion per year. And reduced hours and reduced productivity means a strain on all workplaces and all employees. A study that just came out just this week said that women are more susceptible to long COVID than men, believe it or not. And I don't know where the basis of that study is, but that is pretty interesting. What are the impacts in the workplace? Tardiness, absences, or extended leaves, more demands on existing staff, again, when you've got absences, and that could result in overtime or burnout, and perhaps even resentment or turnover when a coworker suggests, well, why is it so-and-so's out all the time, and claiming that we've all seen this before with the abuses of, or perceived abuses of FMLA, and now perhaps someone claiming I can't be there because of the symptoms of long COVID. But let's be clear, long COVID is very, very real. What are some of the legal risks for employers? Well, principally, we're talking about FMLA or ADA, but there are other considerations too. What could those be? Those could be sick leave and other paid leave programs. They could be paid family leave under, again, state laws, short-term disability, long-term disability, SSDI, Social Security Disability Insurance, COBRA, and that could be because of either termination of employment, or more likely, the other qualifying event would be a substantial reduction of work hours. And yes, unemployment benefits, you might have a situation in that regard where someone is partially unemployed. What should employers do in response to an employee experiencing or disclosing long COVID issues? Well, certainly listen to the employee and consider medical and other documentation, but principally medical documentation. Review with the employees, eligible employees, that is, conditions that might qualify for FMLA. Engage in the ADA interactive process, which of course, as you know, is individualized, unique to that individual and that person's job. And when appropriate, offering other types of leave and benefits, and don't rule out workers' comp. Seriously, workers' comp? Yes, there are many states that during COVID said that COVID could be a workers' comp covered by workers' compensation. Some just for emergency or first responders, but other states said that anyone claiming that their condition either was caused in the workplace, but more likely exacerbated by the workplace, whether it's physical or mental conditions, could be covered by workers' comp. I mean, expect pushback from the comp carrier, but if the person says it was attributable to the workplace, that it may be a reportable event to your comp carrier, and let them handle the matter. Again, there was a lot in state legislatures during COVID on that issue. And that's one to certainly keep an eye on. But again, the most important thing in that regard is looking at, is the person eligible for FMLA leave? If it is, go through your standard FMLA process of, the person requesting, no magic language, but requesting time off if the person's eligible, if you are covered as an employer. But remember that for purposes of FMLA, if you have remote workers that report into a location, they could be counted towards the 50 employee total within a 75-mile radius. Also, employees seeking medical assistance, if they're getting telemed assistance, that may be covered under the continuing care of a healthcare provider. And then you're getting the physician certification, whether it's intermittent leave, reduced schedule leave, or block leave, tracking that time, and so on. And you can also get the second and third opinions, as you know, under the FMLA. Could long COVID be considered to be a disability under the ADA? And the short answer is yes, because it's a physical or mental impairment that significantly interferes with a major life activity. And that could be just about anything, including working, but not necessarily working. So if that's the case, the person may be considered to be disabled, but then the next part of the analysis is, are they a qualified individual with a disability? Meaning, can they perform all the essential functions of the job with or without reasonable accommodation? And so that's something that you have to potentially engage in with someone who claims to have the effects of long COVID. The problem is, the things that we're talking about with long COVID is, first, our healthcare professionals can't really determine whether it's COVID related or it's caused by something else. We're talking about respiratory issues, we're talking about circulatory issues, we're talking about impact about every single body system, physical and or mental issues. And so is that environmental? Is it genetic? Is it short term? Is it chronic? Don't know. All we know is that the statistics for long COVID could be days, weeks, or months, and the early predictions were that long COVID could last up to three months. That has now been revised to long COVID symptoms could last at least a year from the original infection. And again, it's hard to, for purposes of determining whether or not it was caused by an original COVID infection or something else, or subsequent COVID infection, or as some say, perhaps suggesting it was caused by the vaccines. Why bother with the analysis? The bottom line is you've got someone with a physical and mental impairment. The question is whether or not they're disabled, and if they're disabled, whether or not they're a qualified individual with disability. So you go through that same interactive process, the back and forth of the employee and his or her healthcare provider, and determining whether or not it's something you could accommodate, or if it's going to represent an undue hardship upon the on the workplace. Just tread lightly, tread lightly. There certainly could be some abuses in that regard, but be aware that the science, just like the science with the COVID virus itself and the vaccines, is evolving. So some legislative issues to be heard in the workplace, basically dealing with workplace claims and job preservation. Life-Saving Leave Act dealing with time off for donations, bone marrow and otherwise. And there's a statute with regard to, a proposed bill with regard to wage theft in the workplace. And what you're thinking about there is wage theft typically is something that we focus on with regard to employees falsifying time. This is actually employers not paying wages, all the wages due to employees. Some bills I want to focus on in New Hampshire: medical marijuana as an accommodation. Medical marijuana has been there. There's been at least 2 cases now in New Hampshire where under workers' comp it was accepted, and then as a in another case it was considered to be a reasonable accommodation person's medical marijuana use. They have an MMID card and using that. The issue is, like in the Barbudo case in Massachusetts, is this a safety sensitive position or not? And that's even in the sort of the liberal state of Maine with regard to its marijuana laws. They still have a line in the sand with regard to safety sensitive positions. Increase the state minimum wage. Like I said, there are 3 bills in the legislature right now, and I don't think they're going anywhere. Legalization of recreational marijuana. There are 4 bills in the legislature right now. Similarly, they don't seem to have any legs at this point, but I think it's only a matter of time. Again, we talked about requiring paid for unused vacation time. Andrea testified on that one. I testified on another one dealing with the changes to the Commission for Human Rights and the rights of employers to withdraw the case at a certain point. There's actually a working session at the legislature today that I'll be going to on that bill. Again, allowing payroll cards and mandatory direct deposit is up before the legislature, and there's some resistance on that one. Going back to the early days of the Department of Labor on this issue, the notion was that, you know, employees don't necessarily have bank accounts, or there are issues with regard to disputes within families and access. So you can't require mandatory direct deposit and so on, or payroll cards that people might not be able to use. The payroll card issue also was an issue. I think it was a large retailer was using them and they were cashing them in the workplace, but because they were not a bank, whether or not that was acceptable. And the duration of unemployment benefits were now, again, coming out of COVID. The question is whether or not that should be re-examined, and there's push and pull on that as well. What's on the horizon? Again, legalized marijuana, legalized psychedelic mushrooms. Seriously? Absolutely. There are 2 states, Colorado and Oregon, have legalized psychedelic mushrooms. And those are therapeutic. They're to be administered in a healthcare setting. The efficacy of mushrooms has been established and can treating certain disorders. But the question, of course, is we go back to the early days of legalization of marijuana, whether or not it's subject to abuse. So if you've got workplaces in Oregon and Colorado, you want to take a look at your drug and alcohol policy. And again, it's on a limited basis and it's in a therapeutic setting and it's monitored. But still, that's something you want to look at if you have drug testing and the remnants of the mushrooms are in the person's system and you're testing in the workplace, how you're going to apply your policy. My short answer on that would be if the person's impaired and they're in a safety sensitive position, that's one that could be a violation of your policy. Are we seeing an end to non-compete agreements? Well, largely non-compete agreements are not that effective anyway. They've been narrowed by legislatures and by courts over the last 15 years anyway. What is more effective, as one of our partners, Dave McGrath, talks about pretty regularly in his practice, is a non-solicit or a non-disclosure or an NDA agreement are just as effective, if not more effective, and certainly enforceable. Meaning for a period of time, you cannot solicit employees or solicit customers with whom you had access, as long as, again, that's something that's directly tied to the employer's goodwill and reasonable business needs. And then it's reasonable time and scope of those protections. So that's something to look at too. I just saw one the other day in Florida. That was a 5-year non-compete. Talk about, I mean, that to me is back to the age of dinosaurs when you see that. But there are some states that still permit some of these longer term and broader non-compete agreements. But again, we're in an age where you're trying to find employees and retain them. And that is something that could certainly chill those discussions. Indefinite accommodations, are they reasonable? Generally speaking, the answer is no. In 2016, the EEOC came out with guidance in that regard and said that no, that indefinite accommodations may not be reasonable. Again, it's an individualized assessment or analysis. I think which could change things a little bit could be long COVID. So that's something that should be monitored. There are a couple of cases out of the Sixth Circuit dealing with the exhaustion of FMLA, and then when ADA kicks in for someone who can't return to work right away. And those cases basically talk about additional week, sure, maybe 2 weeks, possibly as much as a month. Okay, maybe, again, individualized assessment or analysis. But beyond that, the ADA is not necessarily a leave statute. It's an accommodation statute, and longer accommodations may not be reasonable. But again, long COVID could change that. With regard to 4-day work week, again, we're seeing that in Massachusetts. We're seeing that in other states looking at that as well. We'll see, but some employers are already doing that on their own. Again, for purposes of retaining employees, but they're also looking at the same time productivity. And robots taking attendance. Well, again, we're talking about AI in the workplace and automation of certain functions, and who knows? But I don't know if you can, on the menu of excuses as to why I was late for work today or otherwise, going through that option. You've had those options before with an automated system, and whether or not you might have other as a reason, whether that's acceptable by something automated. So the short answer is that COVID turned the world upside down. We all know that. The workplace was not immune. COVID has shown us that we are all resilient, and principally HR people, for sure. You've been through a lot in the last 3 years. Everything from shutting down your workplaces and scrambling to get technology to employees so you could keep the trains running, but also dealing with screening issues, everything from temperatures to who someone's exposed to, and to what the symptoms are, and quarantine and isolation, and then the accommodation issues going back. The new normal is here, which means there'll likely be even more changes on the horizon as the workplace and our culture evolves. And that means employers need to thrive and adapt, but we are certainly confident you will. Changes remain, or challenges remain, and more to come. But if we can survive the pandemic, and we have, again, there were certain, there's no question of the impact upon individuals, families, our nation. But we're in a post-pandemic era, and we have the tools and experience to deal with just about anything. And there's no question in that regard. So speaking of questions, that's where we are at this point. And we do have a Q&A function. I'm not sure if you folks have any questions, but I hope this was helpful for sort of a quick review as to where we are. I want to mention one other thing, because it was on LaborNet the other day about I-9s. The guidance came out with regard to changes in I-9. Again, the I-9s were extended, meaning you could review remotely or virtually the documentation to support someone's identity and authorization to work in the US. That is ending as of July 31st. And for your remote employees that you check things before for purposes of rechecking those, it's the end of August. John Wilson, I think, was on LaborNet the other day suggesting that they're recommending to their clients that they get back to in-person examination again under the certification section under the I-9s. That is certainly sound advice. So I hope this has been helpful this morning. Seeing no questions, which tells me I was absolutely brilliant and no one was left wondering anything. I'm going to say thank you for being a part of it and say that we will see you in September. Thanks so much, and stay tuned for more events. In the meantime, these are the SHRM credits. Again, Liz Tezik will be sending you out information with regard to not only these credits, but also a copy of the program and any other questions, any other administrative questions, you can certainly ask Liz. But thanks for your attention. Have a great rest of the week.